All right, so we have a new trial date set in the YNW Melly case. And so this news came out relatively quickly. The trial date is October 2nd. So YNW Melly will be right back in front of a jury fighting for his life in these double murder charges. And so the system essentially worked out the way it's supposed to. And before I go any further on that, I definitely want to, pay respects to the two individuals and their families. Obviously, two young men lost their lives. They are never coming back, and they have friends and family and loved ones who I'm sure miss them dearly. They unfortunately, missed out on any sense of closure as it relates to, who could have done this. And that can oftentimes be trials can give people closure in that sense when they do finally find out that this person did it, or, if they already knew that the person did it and they're ultimately found guilty and they're sentenced, whether that's to life or the death penalty or whatever amount of time they get, then the alleged victim, if it's not a murder case, the alleged victim can get a sense of closure, or if it is a murder, then their families can get closure. But unfortunately, we didn't get that here. But with that aside, the presumption of innocence is a real thing, right? And we as defense attorneys, it is something that we harp on in jury selection, because the judge is going to instruct the prospective jurors on the presumption of innocence. When you have a jury impaneled and you're in trial, the judge is going to instruct the jury on the presumption of innocence. And we as defense attorneys are going to mention in our closing arguments the presumption of innocence. Anyone in this country who is charged with a crime is presumed innocent, right? They enjoy the presumption of innocence, such that unless and until the prosecution meets their burden of proving guilt beyond a reasonable doubt, they are innocent. And this also comes up in jury selection when, you're talking about the natural inclination to think that, okay, well, because the guy got arrested, right? Because the police decided to arrest your client, that doesn't mean that they're guilty, right? All the police need is probable cause in order to make an arrest, right? The police don't need proof beyond a reasonable doubt to make an arrest. That's not for the police to decide. If they find that there's reason to believe, just reason to believe that a crime has been committed, and reason to believe that the person arrested committed that crime, then they make the arrest. They get their files to the DA. The DA then reviews the case and decides if they're going to issue the case. And then, again, obviously, they have the burden of proving guilt beyond a reasonable doubt. But the DA's decision to file the case doesn't mean that your client did it, right? And this goes to be part of your arguments at trial, in closing arguments. Just because the police arrested my client doesn't mean that he did it. Just because you had detectives and police officers taking the stand and saying that, they believe that he did it, hey, it's your job as the jury. You guys are the fact finders. You are the one that are ultimately going to determine what the facts were in this case, right? And so it's really important that we make sure that jurors understand this and keep the burden where it lies with the prosecution. If the DA can't meet their burden of proof, then the verdict has to be not guilty. It has to be. And you saw in comment sections all over the place about this case, people are saying, oh man, I know he did it, or I feel like he did it. Well, and I get that, right? Because even in looking at the facts of the case and what the allegations were, it's like, okay, well, maybe the DA is just going to easily be able to prove this case. But apparently the jury who sat through the 19 days of this trial, right? All the evidence being presented, all the witnesses testifying, sat there with an open mind, listened to this evidence, and there were enough people who decided they didn't meet their burden, they couldn't reach a verdict. There may have been, and again, maybe you watched the trial and maybe you came down differently, but there was at least one person, right? There was at least one person who found that the DA did not meet their burden of proof. And And make no mistakes about it, this is a victory for the defense in this case, right? Again, with the prosecution having the burden, they go into this, at least they're supposed to go into this. If they're issuing a case, right, and they don't dismiss that case, then they have to believe that once they put this in front of a jury, that jury is going to find the accused guilty, and they're going to find that they, prove their case beyond a reasonable doubt. That's what the DA has in their mind. But obviously, the jury didn't agree. All right. And so, one thing that we say as defense attorneys is it only takes one to hang, right? It only takes one to hang. And what that means is if, again, there has to be a unanimous verdict one way or the other. Either 12 people vote guilty or 12 people vote not guilty. If you have a mix, whether that's, 11 people say guilty and you have one holdout juror, then boom, you have a hung jury, and it's a mistrial. And, that's what we had here. Again, I don't know what the split was, but at least one person had to have said, hey, they didn't meet their burden of proof, and that's how we have this hung jury. And so, and it was very early on. A lot of times you may have where, the jury's not able to reach a decision after a number of days. But in this situation, it was reported that, hey, within the first 24 hours, the jury was already sending a note to the judge saying, hey, what do we do if we can't get on the same page, right? And so the judge, obviously he's been doing this a long time. He's trying to salvage the case because he understands all the resources that went into this on both sides, right? He's trying to see, if they might be able to reach a verdict. So he's saying, hey, go back to the deliberation room, don't form an opinion. Maybe just keep an open mind. Let's hear everybody out, right? Maybe give the strengths of your side, the weaknesses of your position, and then you guys collaborate and see if you can maybe reach a unanimous decision. And, they were deadlocked and, went on for a couple days. I believe it went on for about 3 days. And then finally it's just like, okay, we're not getting anywhere. So this, it's a hung jury and it results in a mistrial. If you're the defense, you're absolutely happy that you ended up with a hung jury because, again, all it takes is one. And, you'd like to think, or at least maybe some of you thought that because it was a hung jury and a mistrial, then YNW Melly would go free and go about his life. But no, that's not the case. The case was not dismissed, right? He was not acquitted. There wasn't 12 jurors finding him not guilty. So that means that the district attorney has the option to decide if they're going to retry the case. And retry just means, hey, run back the trial. We're going to do this all over again, right? And, while the DA is taking this into consideration, obviously, if you're YNW Melly and the defense team, you're really hoping, right, that they decide, it's not worth it, right? Because, yeah, the DA has the choice. I mean, they could offer a deal, right? In this situation where the DA, they put on the case in front of the jury, comes back hung. The DA has the option of dismissing the case. They could offer some sort of deal, or, they could say, hey, we're going to retry this, right? And obviously, that decision has been made that they're going to retry it. But obviously, if you're YNW Melly, you're really hoping that they say, no, we're not going to retry this. I mean, YNW Melly was literally fighting for his life. He's facing the death penalty. In deciding to retry the case, the DA obviously has some serious analysis to do. But ultimately, since they have made the decision that they're going to retry it, they have to believe that they can secure the guilty verdict this time around, right? And you're one of the things you're going to look at is the split, right? And I don't know how the jury came back, if that's even been reported. The more guilty votes there were, the stronger the DA is going to feel about their case, right? So if they got 11 guilty and 1 not guilty, then they're going to feel like, hey, man, we put this thing on again, we can probably sway 12 people this time around. Right. But as that number, creeps down, if you have 3 not guilty and so therefore 9 guilty, then you're like, you don't feel quite as strong than if it's 11-1, right? If it's 6-6, then that's difficult. I mean, if it's 6-6, you may not even decide to retry it. If it's swaying the other way, where you have only, say 3 guilty and 9 not guilty, then, you're pretty much in territory where it's like, this is not worth retrying. And certainly if it's 11 not guilty and 1 guilty, then no, right? So you're going to look at the split. You're going to go back and, look at how the evidence was presented. Look at the testimony. At closing argument, did you do the best job in, tying up the evidence and presenting the law and fact and the marriage between those two? Could you have tightened up some of those arguments or maybe presented it in a different way? So again, they've made this analysis. There's certainly pressure there to put on a trial in front of a jury. It's expensive, and especially in a case like this, in a homicide case, stakes are higher. There's a lot more resources that go into it. The DA is going to have had a whole team of DA investigators and paralegals and lawyers and supervisors checking off all the boxes and their involvement with the police to get everything ready to go and all of that. So it's really expensive. It's really expensive to try a case. And so they have to go into this again thinking that they're going to get this guilty verdict, or, if this thing blows up in their face again, that's going to be kind of embarrassing. And make no mistake about it, we as trial lawyers, whether, defense or district attorneys, we're competitive, right? We want to go into this thing to win. We want to get the verdict that we're shooting for. On the defense side, we're looking for an acquittal, or we're looking for at least a hung jury, right? On the DA side, they're looking to prove guilt beyond a reasonable doubt. And so in going into this, I think, there's definitely pressure on the defense as well, right? Especially with stakes being this high. If your client's on trial for double murder and facing the death penalty, then, that's going to be pressure. When you're representing somebody facing life in prison, there is certainly pressure that comes along with that. But, I'd say there might be more pressure on the DA, right? Because, at the end of the day, the defense, like I said, they got the victory the last time. This hung jury, this mistrial was certainly a victory on the defense side. So they're going into this confident, right? We know we did this once, we can do it again. On the DA side, they have to, sit with the fact that they couldn't get it done this last time. And can they do it this time, right? It's almost like, when you have an NBA playoffs game and you stole one on the road, right? And so it shifts back that other team. If you got another one, then you got to try and, shift that momentum back. But you lost at home. And so now you got to make up ground, and that's going to give the other team confidence that they were able to pull off the win on the road. So that's what the defense is in this situation. They got the win on the road, and now, it's on the DA. The pressure is on the DA to try and get the momentum back and get this done. And I don't mean to make this, as trivial as a basketball game, but that is a way to look at this thing. But I'm curious, what are you guys' thoughts on this situation? Did you actually watch the trial? Did you find the trial to be interesting? Again, I mean, I didn't really see the trial footage. But again, with no murder weapon and no apparent motive, I think that makes it really difficult. I mean, juries tend to want to see, where is the murder weapon? What is the murder weapon that was used, and what is the motive? Motive is not an element to an offense, so the DA doesn't have to prove motive, but just in the real world, it's something that juries tend to want to see. So where we have Mr. Dimmons, YNW Melly, alleged to have killed 2 of his childhood friends with no apparent motive, that's really difficult to sell. So we'll see. I mean, again, the DA has made that decision. They're moving forward. We're supposed to be going forward with jury selection on October 2nd. And so we'll see how it plays out. But let me know, what do you think? How do you see this thing playing out the second time around? I know some people were upset that this didn't just result in a dismissal, feeling like, hey, if 1 or 2, 3 people find him not guilty, then he should have had the benefit of that and the case should have gone away. Unfortunately, that's just not what the law says, but I understand that position. I really do. So, if you got something out of this, please show me some love. Hit the like button. Make sure you subscribe to the channel, turn on those notifications so you never miss a new video when it drops. As always, I want to thank you so much for watching, and until next time, peace.